Screaming in the courtroom, great elephant, defending the innocent, mind sharper than a tenement. Criminal defense game stronger than cement. Out here wrecking cases so your time ain't spent. Suits clean as the glass, arguments intense. Great elephant in the zone, watch you commence. Skipping past objections, mind so immense. Law books talent, but the flow never fence. Dropping legal, heavy on the box. Great elephant got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock. Tell the judge to relax, swinging the parole. Jury nodding head, great elephant control. No sweat under pressure, ice in his soul. Out of cuffs, break free, legal as his goal. Late nights grinding, paperwork and stacks. Great elephant be flexing facts. From the churches to the marble floor, straight facts. Criminal defense, kingpin, never falling back. Dropping legal, heavy on the box. Great elephant got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock.
In the courtroom, tall and bright, great elephant stands with might. Justice served both day and night. Great elephant in the light. Wears a suit that's always neat. Every client he will greet. Victory never feels defeat. Great elephant can't be beat. Great elephant fighting for the right. Great elephant shining so bright. When the battle strikes the wood, great elephant is only good. Wins the battles like he should. In the law he's understood. Always calm and always fair. In the courtroom with a stare. Great elephant does declare injustice won't be spared. Great elephant fighting for the right. Great elephant shining so bright.
Well, here goes nothing. Said I'd be going live today to discuss some new laws in Louisiana related to criminal defense. Some of them are going live today. The first one we're going to talk about, I'm sure a lot of people want to hear about this one, but this is a brand new law. It takes effect today. I'm 100% against it, but I don't make the laws. I'm not a legislator. I'm not the governor. But the first law I want to talk about is Act number 1. Now, this act gives 18-year-olds or all adults 18 years or older the right to carry a firearm, a concealed firearm, no permit. I'd love to hear your thoughts on this act. Do you think it's a good law or a bad law? Do you think it's something we should see what we can do to change as soon as possible? So let's go through this act. To amend and reenact 1495M and to enact 1495N relative to illegal carrying of weapons, to provide that law-abiding persons 18 years of age and not otherwise prohibited may carry a concealed weapon lawfully without a permit. So, everybody in this state who's now 18 years or older, you have a right to possess a firearm, a concealed firearm. I don't think this is good, folks. I'd love to hear your thoughts in the comments, but this is in fact the law in the state of Louisiana now. So let's look at the previous law, 1495M, illegal carrying of a weapon. The provisions of paragraph A of this section shall not apply to any person who is 18 years of age or older and is not prohibited from possessing a firearm under 1495-1 or any other state or federal law. So the law used to be if you were 18 years old or younger, you could not possess a firearm. Now, if you're 18 years old or older and you're not a convicted felon, you're not under restrictions by a restraining order, or there's not some other law or prohibition against you owning and carrying a concealed firearm, you can now do so. And this law takes effect today. It's effective July 4th, 2024. We're going to get to that at the bottom of the statute, but I know a lot of people want to know that. So I'm just going to put it out there. This law is effective now. So what else does it say? Under section N, any person lawfully carrying a handgun pursuant to section M of this section shall be subject to restrictions in revised statute 1379.3. And we'll take a look at those. A person who meets the qualifications of 1495M, 18 years old or older, shall not be required to possess a valid concealed handgun permit issued by the state of Louisiana pursuant to the provisions of this section in order to carry a concealed handgun in the state of Louisiana. No concealed handgun may be carried into, and no concealed handgun permit shall be valid or entitle any permittee to carry a concealed handgun into any facility, building, location, zone, or area in which firearms are banned by the state or federal law. So all this means, people, the law doesn't change with respect to a few things. You can't bring your concealed firearm onto a school property. You cannot bring your concealed firearm into government buildings. If you do, you're committing a crime, a serious crime, so don't do it. If you're not going to remember to remove that concealed firearm before entering one of these places, I would suggest you not even carry one. So let's go on. The provisions of subsection N of this section shall not limit the right of a property owner, lessee, or other lawful custodian to prohibit or restrict access of those persons possessing a concealed handgun pursuant to a permit issued under this section, or a person lawfully carrying a handgun pursuant to 1495M. So, all that means is, if you go to your friend's house or a friend of a friend's house and you're carrying a concealed firearm, that person can say, no, you cannot come into my house with that firearm. If it's their apartment, their business, any establishment they own, they have a right to prohibit you from entering with your firearm. So, does anybody have any questions about any of this right now? I see Charmaine Green. So this law allows me to just go in a store and buy a gun without any knowledge of guns. Yes, it's horrible, isn't it? It's a horrible, horrible, horrible deal. There's no requirements of gun safety. You could have never seen a gun in your entire life, turn 18 and decide, I'm going to get a gun. That's what this law now allows. And it's going to be bad. I believe there's going to be a lot of serious consequences as a result of this law. It's irresponsible. For our legislators to pass this law is completely irresponsible. And I believe it's going to lead to some people being injured. It's going to lead to the loss of human life. And I believe it needs to be repealed. Or some kind of parameters or provisions need to be put in place that at least requires these 18-year-olds to be evaluated, to understand gun safety, and those sort of things. You know, as a criminal defense lawyer, and the guys I know that do criminal defense, we've talked about this law, and we know it's going to lead to many more young adults and teenagers, well, not teenagers because they're not supposed to have one, but it's going to lead to many more young adults resolving to gun violence. We already live in a culture where people don't believe in putting the dukes up and fighting it out and making up later. It's shoot first, figure it out later. You know, we used to fight and we'd make up later. Maybe we'd fight a second time or a third time. But that's not the world we live in. And now we're going to turn around and stick guns into the hands of 18-year-olds and expect them to act responsibly. I don't even believe that the legislature could even expect these young people to act responsibly. But for whatever reason, there was a strong push to make this legal, and that's the state of the union as far as the Union of Louisiana goes, starting today. So I probably jumped. I talked about number 2, just running my mouth. No individual to whom a concealed handgun permit is issued or who is lawfully carrying a handgun pursuant to 1495M may carry a concealed handgun into a private residence of another without first receiving the consent of that person. Now that sounds great in theory, right? Let's say a guy comes to your house. Maybe you know him, maybe you don't. I don't know everybody that comes to my house for crawfish balls, but he or she comes to my house with a concealed handgun, and I say, you can't come in here with that gun. Now, what do you think can happen in a situation like that? If this is a normal, law-abiding, upstanding person, they'll probably return the firearm to their vehicle. But we've all seen and heard cases where somebody just spazzes out because we live in a culture where people don't like being told what to do, even if what they're doing is wrong, even if they're stepping on the next person's toes or rights. They just don't like people to tell them what they can or cannot do. And in those situations, what's going to stop this person who's lawfully carrying a concealed weapon from shooting a homeowner for simply saying, please don't come in my house with your gun? Charmaine Green, I see you got another comment. If they look at all the killings that's taking place, it's that age group. Now you give them permission to carry. That's my point exactly. I couldn't have said it any better. You hit the nail on the head. most violent crime is committed by individuals between the ages of 14 and 25. And we have research that shows that the part of a male brain that controls rational thinking, it does not fully develop until the age of 24. And think about it. A lot of us guys, we can think about some of the dumb things we did, in that age range, 14 to 24, 25. We did a lot of dumb stuff back then we wouldn't do now. One thing I didn't do was walk around with a concealed firearm because I wasn't allowed to. And now they're allowed to. So this is going to play out over the next few years. I'd imagine it's going to have to be revisited because we've given these young kids a blanket right to now purchase a concealed firearm and walk around with it. So let's continue on in the statute that we're talking about. Section 3 says, this act shall become effective on July 4th, 2024. Happy Independence Day. I guess there's going to be some fireworks being let off as a result of this. So let's go to Act 2 that was passed in conjunction with this act that gives 18-year-olds the right to carry a concealed handgun. Act 2 deals with limitations of liability. And I'm going to skip through the parts that I don't think we necessarily need to cover here. But limitations, this is the title of the new law. Limitations of liability, concealed handgun permit. As used in this section, the term authorized person means any person with a valid concealed handgun permit pursuant to these statutes. Any qualified law enforcement officer authorized to carry pursuant to these statutes, or any person specified under 1495, G3 and 4. So let's continue on. An authorized person as defined in this section shall not be liable for damages for any injury, death, or loss suffered by a perpetrator when the injury, death, or loss is caused by a justified use of force or self-defense through the discharge of the handgun by the authorized person. This provision shall preclude any right of action by the perpetrator, his survivors, or his heirs. So this just kind of recites the law of self-defense. We've always had the right to defend ourselves. The provisions of subsection B shall not be applicable to the following: acts or omissions that constitute gross negligence or intentional misconduct, or that result in a valid and final felony conviction in this state. So if a person relies on this statute and then they subsequently are found guilty of a crime, or it's determined they acted intentionally, they can still be sued civilly, which means for money. And subsection E is important. Nothing in this section shall be construed to limit third-party liability and property damage exposure from a criminal actor's contributory negligence that causes the lawful actions of the individual claiming limitations of liability. So what does that mean? Quite simply, if you use your firearm in self-defense and you shoot an innocent bystander, damage an innocent bystander's property, that innocent bystander can sue you. Now, they probably have an action against you and the person you're defending yourself against, but nevertheless, you will still be subject to liability for causing injury to damage or property of an innocent bystander. All right, Gerard Griffin. So with the law changing, that means 18 plus can purchase a handgun. Yes. Or just conceal one, meaning you're not the rightful owner. Well, you have to be the rightful owner to be able to conceal it. So you can purchase and conceal. I guess that's an interesting question, though. The law probably should be clear on that because that's really a fair question. Let's go back and look at it. So yeah, Mr. Griffin, I would agree. The law is somewhat silent on purchasing the firearm, but you gotta be not otherwise disqualified from purchasing a firearm. I don't know if you heard me earlier, but if a person is a convicted felon, or if they're currently under restrictions by a protective order, what most people call a restraining order, then you won't be allowed to purchase a firearm. And if there is some kind of mental health defect that disqualifies a person from purchasing a firearm, you can't purchase. But if there's no prohibitions against you purchasing, then you can purchase a handgun, 18 years or older, and you can carry it. So we were still on limitation. We covered limitations of liability. So before I move on, I'm going to play a little song, and I want you guys to let me know your thoughts on the song. And also let me know if you have any questions, because that's pretty much all I'm going to cover with respect to 18-year-olds carrying firearms. Now I'm going to talk about parole eligibility, good time, and probation and parole revocations. So take a listen to this song. I'll be right back.
In the courtroom's tall and bright, great elephant stands with might. Justice served both day and night. Great elephant in the light. Wears a suit that's always neat. Every client he will greet. Victory never feels defeat. Great elephant can't be beat. Great elephant, fighting for the right. Great elephant, shining truth so bright. When the gavel strikes the wood, great elephant does all he could. Wins the battles like he should. In the law he's understood. Always calm and always fair. In the courtroom with a stare. Great elephant does declare injustice won't be spared. Great elephant, fighting for the right. Great elephant, shining truth so bright.
Great elephant in the court, stomping ground, defending the innocent, justice profound. In the jungle of the law, he stands tall. No case too big, no crime too small. Things guilt break when Trump can steal. From the boardroom deals to the courtroom field. Clients or objection, silky smooth. Clients breathe easy, knowing they'll groove. Like a percent scales tip in his favor. Gavels banging, freedom is his
All right, welcome back. So tell me what y'all think about the songs. I did receive a questions from Rachel Paul or Rachel Paul. Hope I got it right. But the question was, how do they check for mental health illnesses? So they check for mental health illnesses the same way they check for criminal backgrounds. There is a National Instant Criminal Background System. It's called NICS. And there's supposed to be a record of individuals who have been disqualified from purchasing a firearm due to mental health issues. Now, it's a government database just like everything else. So, as we know, these things sometimes slip through the cracks, and people that should not own firearms end up owning them. So if I have no more questions on that, I'm going to move on to Act number 6, which deals with parole eligibility. So under 574.4 parole eligibility, a person otherwise eligible for parole shall be eligible for parole consideration upon serving 25% of the sentence imposed. This won't apply if the person has a crime, is convicted of a crime of violence or a sex crime, or if it's if you have 4 or more felonies for nonviolent offenses, this won't apply to you. Going back to a question about the concealed firearm posed by Ronika Redford Stokes, what does it mean for those who have a concealed carry permit? Is that no longer valid? It's still valid. You don't lose any rights. You don't have any additional rights either over individuals who do not have that permit. It's just, I don't know why they passed this. I would say there's not going to be a need to renew that concealed weapons permit. Notwithstanding any provisions of law to the contrary, the provisions of this subsection shall not be applicable to persons who have committed offenses prior to August 1st, 2024. So this parole eligibility is going to apply to crimes occurring August 1st, 2024 or later. If you have a loved one who's currently incarcerated, their parole eligibility is going to be based on what the law is today. Whatever they were told when they were convicted or took a plea and received their time from DOC, the percentage of time is going to be different. It's going to be based under the old law. Notwithstanding the provisions of paragraph 1 that we just covered, a person committed to Department of Public Safety and Corrections for a term or terms of imprisonment with or without parole for 30 years or more shall be eligible for consideration upon serving at least 20 years of the term of imprisonment in actual custody and upon reaching the age of 45. So if somebody gets a 30-year sentence, they're going to have to do at least 20 before they are considered for parole. This provision shall not apply to a person serving, let me back up. The person is going to have to do at least 20 years, and they're going to have to be at least 45 years old. So it's kind of, if you think about this in conjunction with the law giving 18-year-olds the right to possess a firearm, we know most violent crime, especially violent crime, is done by young people, and then we're locking them up for majority of their useful adult life. So I don't know the rationale behind this. I don't know the thought process, but it's just do a good job of raising your children. Or do the best you can. That's my advice to everybody on this call. The provisions shall not apply to a person serving a life sentence unless the sentence has been commuted to a fixed term of years. So if somebody gets life without parole, it still means life without parole in Louisiana. It means you go to prison, you die in prison, and unless your sentence is converted to a number, that's what they mean by fixed term, a number of years, then you're not going to be eligible for parole. And obviously it doesn't apply to a crime of violence or sex offense after January 1st, 1997. Then there's a little bit of a difference here because the law is always changing. The provisions of this paragraph shall not apply to any person who has been convicted of a crime of violence or a sex crime when the offense was committed on or after August 1st, 2014. So let's look at this 1997 application compared to 2014. If you were convicted, if your crime happened on or after January 1st, 1997, this does not apply to you if it's a crime of violence and a sex offense. However, if your crime or your family member's crime occurred after August 1st, 2014, this provision does not apply if it's a crime of violence or a sex offense. So after 2014 is one or the other. After 1997, so basically from 1997 until 2014, it had to be a crime of violence and a sex offense for this provision not to apply. After 2014, a crime of violence by itself was enough, a sex offense by itself was enough. All right, so I got another question. Charmaine Green, so does this apply to people fighting cases currently? I'm going to go back to the top for you. It says, notwithstanding any provisions of the law to the contrary, the provisions of this subsection shall be applicable to persons who have committed offenses prior to August 1st, 2024. So this part does allow persons who are currently incarcerated because the offenses are committed prior to August 1st, 2024. Now, when we get a little further, it's gonna all make sense. So let me continue on for you, Miss Green. All right, let's look at this because they're really trying to tighten down on people who produce and sell heroin. Notwithstanding the provisions of paragraph A1 or 2, unless eligible for parole at an earlier date, a person committed to Department of Public Safety and Corrections serving a life sentence for the production, manufacture, distribution, and dispensing or possessing with intent to produce, manufacture, or distribute heroin shall be eligible for parole upon serving at least 15 years of imprisonment in actual custody. And then section 4, unless eligible for parole, a person committed for a term of imprisonment with or without benefit of parole who has served at least 10 years of the term in actual custody shall be eligible upon reaching the age of 60 years if all of the following conditions are met. So this is just an attempt to allow older individuals to get out of prison for felonies that are not significant or serious felonies like crimes of violence or sex crimes. so I'm not going to cover all of this. We talked about a person serving a life sentence. It has to be converted to a fixed term of years for them to be eligible. All right, so Ms. Green, let's look at, this is a brand new statute of 574.22. No person committed to the Department of Public Safety and Corrections for an offense committed on or after August 1st, 2024 shall be eligible for parole under this part except a person who satisfies 1574 D, E, and F. So let's take a break and I'm going to pull those up. A, B. A, D. All right, let's try to go through this statute. It's, as you can see, it's massive. Notwithstanding any provisions of law to the contrary, any person serving a life sentence of life imprisonment who was under the age of 18 years at the time of the commission shall be eligible for parole if all of the following conditions are met. So this statute deals with juveniles who commit murder and receive a life sentence. A few years ago, the U.S. Supreme Court deemed that it was unconstitutional to give a juvenile life without parole without an opportunity for freedom at all in their lifetime. Now, there's still some pretty serious consequences for juveniles who commit these crimes, and it's still a hurdle for them to be released. A says the offender has served at least 25 years of the sentence. The offender has not committed any major disciplinary offenses in 12 consecutive months prior to the hearing date. The offender has completed mandatory requirements of 100 hours of pre-release programming. The offender has completed substance abuse treatment as applicable. The offender has obtained and completed one of the following. There's 4 options: a literacy program, adult basic education program, job skills training program, or a high school equivalent certificate. The offender has obtained a low-risk level designation determined by a validated risk assessment with the Department of Public Safety and Corrections. The offender has completed a reentry program determined by the Department of Public Safety and Corrections. H, if the offender was convicted of aggravated or first-degree rape, he shall be designated a sex offender and upon release shall be required to register as a sex offender. And I'm on live. And under part 2, for each offender eligible for parole consideration pursuant to the provisions of this subsection, the Committee on Parole shall meet in a 3-member panel, and each member of the panel shall be provided with and shall consider a written evaluation of the offender by a person who has expertise in adolescent brain development. That's interesting. They know these youth, the brain of young people doesn't fully develop, the part that controls rational thinking. The adolescent brain development and behavior, and any other relevant evidence pertaining to the offender. E, notwithstanding any provisions of law to the contrary, any person serving a sentence of life imprisonment for first-degree murder. The only difference between first-degree murder and second-degree murder in Louisiana is they can seek the death penalty for first-degree murder. And second-degree murder, you can't seek the death penalty. It's life without parole only. Who was under the age of 18 at the time for the offense is on or after August 1st, 2017, shall be eligible for parole consideration pursuant to the provisions of this section if a judicial determination has been made that the person is entitled to parole eligibility. And then it goes on again. I'm not going to repeat the same requirements, having to serve at least 25 years and the classes they have to complete. And it's a little bit different. So a lot of these cases, when people have been in prison for years and years and years, and they're trying to be released finally, we just have to go to the books. We have to go to the law books and try to determine which years they fall under. Which law does this person fall under, and which one is going to be applicable to their release. I think the only other thing I want to cover today deals with good time, which is going to be pretty short, and then parole and probation violations. Actually, I do need to cover that because there's a change that is actually very important. So I'm going to play one more song for y'all, and then we're going to go over good time and parole and probation violations.
Elephant stomping in the courtroom, great elephant defending the innocent, mind sharper than a tenement, criminal defense, ain't stronger than cement. Out here wrecking cases so your time may spent, suits clean as a glass, arguments intense, great elephant in the zone, watch commence, skipping past objections, mind so immense, law books tattered but the flow never fits, trapping legal heavy on the blocks. Great elephant, got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock. Tell the judge to relax, swaying the parole. Jury nodding heads, great elephant control. No sweat under pressure, ice in his soul. Out of cuffs, break free, legal as his goal. Late nights grinding, paperwork and stacks. Great elephant, beat flexing facts. From the trenches to the marble floors, straight facts, criminal defense, kingpin, never falling back, trapping legal, heavy on the blocks. Great elephant, got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock.
So just before we move on, Ms. Green, Charmaine Green, I just want to point you to, just to make sure you're clear on, I've answered your question. 574.4, your question was, does this apply to people fighting cases currently? And the simple answer is yes. It says it at 574.4, A1A, the last sentence in the paragraph. It says, notwithstanding any provisions of law to the contrary, the provisions of this subsection shall be applicable to persons who have committed offenses prior to August 1st, 2024. Now, it looks like from these strike-throughs, they were considering not letting it apply to individuals currently under indictment or facing charges, but it does apply to individuals currently facing charges. All right, so let's look at Act 7, which deals with good time. For those of you who don't know, good time is benefits given to people who are incarcerated that allows them to shorten the amount of time they have to sit in prison. So let's go. 571.3, just the article number in the Code of Criminal Procedure. Diminution of sentence for good behavior. No person who commits an offense on or after August 1st, 2024 shall be eligible to earn nor be entitled to any diminution of sentence or good time except as provided in 15.571.3.1. So let's read what that says, which is the very next statute. If anybody has any questions or as I'm reading this, feel free to leave them in the comment section. No person who commits an offense on or after August 1st, 2024 shall be eligible to earn nor be entitled to any diminution of sentence. Diminution means reduction. Hereinafter known as good time except as provided in this section. So let's continue on. Every offender in a parish prison or in custody of the Department of Public Safety and Corrections who has been convicted of a felony and sentenced to imprisonment with or without hard labor may earn diminution of sentence for good behavior up to a maximum of 15% of the particular sentence imposed. The provisions of this section shall not apply to persons who have been convicted of a sex offense or any person who has been sentenced as a habitual offender under the habitual offender law. I think we generally know what a sex offense is: rape, sexual battery, aggravated rape, aggravated sexual battery. And there's a few other crimes that are considered sex offenses. You're not entitled to this 15% reduction in your sentence for good behavior. The habitual offender laws applies to individuals who, this isn't your first rodeo. If you're on your first, second, third, fourth, fifth felony, then you won't get this reduction for good time. Now, a lot of us lawyers, myself included, have been getting questions quite a bit from individuals who are currently incarcerated and fighting charges. And one of the concerns is, do I need to hurry up and take a plea deal before August 1st, 2024? Because right now, as the law stands now, the benefits, there's a substantially larger benefit for good behavior. 30, 40, 50, 60% off individuals' time is knocked off depending on the particular circumstances of their charge. And the clients who are currently under indictment, or anybody who commits a crime before August 1st, 2024, you will fall under the old law. And if you fall under the old law, you're going to be able to receive a much greater benefit than the new law that's going to take effect in August. That's going to only be 15%. So be aware of that. If you have someone, a family member or friend who's in jail right now for something that occurred, tell them the law that takes effect August 1st, 2024, that says they're only going to get 15% off their time for good behavior does not apply to them. It doesn't mean they have to rush and take a plea deal. It doesn't mean they have to agree to some crazy number because of this law. They are subject to the law that is in effect today. Their good time will be calculated based on the law that is in effect today. So let's go to paragraph C. Just says every offender may earn an additional diminution as provided in 15.828. I haven't read that statute, so unless somebody asks me to pull it up, I'm not going to pull it up right now. But I'd imagine some requirements that people could sign up to and get additional time knocked off. And D and E just gives, let's talk about E. Any diminution of sentence or good time earned under this section shall be subject to forfeiture, as provided in 15.571.4. So if a person cuts up, they can lose their good time. Nothing changes there. G, the Secretary of the Department of Public Safety. The reason I highlight G, and I'm going to read it and then I'm going to tell you why. The Secretary of the Department of Public Safety and Corrections shall have sole power and authority to determine when good time has been earned and when diminution of the sentence may be allowed. The reason I highlight that is because clients routinely ask myself, lawyers, or even when they're taking a plea deal, they'll ask a judge, "Judge, how much good time am I going to get?" The judge doesn't know, can't answer that. The lawyer can't answer that. Somebody at DOC, Department of Corrections, is going to be in the best position to fully answer that. And it's going to largely be based on the behavior while incarcerated. But I can never tell a client who enters a plea deal the exact date he or she will be released. Just don't have the ability to do that. And neither does the judge or other lawyers. H goes on to just say the Secretary for the Department of Public Safety and Corrections has authority to come up with rules and regulations on the specifics for earning good time and how it's applied. All right, 571.5 is important because it's a change in the law. If such person's parole is revoked by the parole committee for violation of the terms of parole, the person shall be recommitted to the department for the remainder of the original full term. And look at what's struck through. Subject to a credit for time served for good behavior while on parole. Subject to credit for time served for good behavior while on parole. So, as the law sits now, if a person is out on parole, they get credit, what's commonly known as, do I get credit for my time on the street? Today, yes. After August 1st, no. You will not get credit for your time on the street if your parole is violated for any reason. You will have to go back and serve the remainder of your full sentence. And that covers parole eligibility. One last thing I'm going to cover today is did I close it? No. Act 8, which deals with parole and probation violations. Come on, computer. All right, this is going to be brief. I'm just going to really cover the change here. Article 8983 deals with suspension and deferral of sentence and probation and felony cases. So, and I'm just going to really focus on this last sentence. The period of probation shall be specified and shall not be more than 5 years. So, as the law exists today, if a person pleads guilty to a crime and is placed on probation instead of sent to prison, the maximum time they can be on probation is 3 years. After August 1st, it's going to be 5 years. It was 5. I do remember when I was a young lawyer, a baby lawyer, no gray hair on my beard, probation terms were up to 5 years, and then we did away with that for a while. And now it's coming back. So if somebody gets put on probation, they can be placed on probation for up to 5 years. Doesn't mean it's going to automatically be 5 years, because this can be negotiated in a plea agreement, but the term of probation can be up to 5 years. All right, Part 3 just deals with the defendant may be placed on probation under the supervision of probation office, agency, or officer designated by the court other than the Division of Probation and Parole of the Department of Public Safety and Corrections. And this just gives the judge some authority and discretion with indicating who a person on probation has to report to if they complete a specialty court program. So the judge can say, this person's going to be on DA probation, bench probation. They don't have to report to Department of Public Safety and Corrections, probation and parole. There's a little bit of discretion there. Now this is a unique scenario because this allows for 8 years of probation. If the court, with the consent of the district attorney, orders the defendant to enter and complete a program provided by the drug division of the district court, an established driving while intoxicated court or sobriety court program, a mental health court program, a veterans court program, blah, 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 the court may place the defendant on probation for a period of not more than 8 years if the court determines that successful completion of the program may require that period of probation to exceed the 5-year limit. So, all this means is, so if the court believes somebody has a drinking problem, a drug problem, a mental health problem, and they say, look, it's going to take this person, we don't think 5 years is going to be long enough for this person to overcome their addiction, their drinking problem, their mental health issues. Let's watch them longer for their own safety. It can be done for up to 8 years. The period of probation as initially fixed or extended shall not exceed 8 years. So that means the court, at 8 years, that's it. They can't go beyond 8 years. All right, let's look at Section H. If a defendant is placed on supervised probation, the Division of Probation and Parole shall submit to the court a compliance report when requested by the court, or when the Division of Probation and Parole deems it necessary to have the court make a determination with respect to modification of terms or conditions of probation, termination of probation, revocation of probation, or other purpose proper under provisions of law. So, if you're trying to get your probation terminated early, the court's going to have to get a compliance report. If the probation officer tries to revoke your probation, he's going to have to submit a compliance report. Article 900 deals with violations or hearings after you've allegedly violated the terms of your probation. After an arrest pursuant to 899, the court shall cause a defendant who continues to be held in custody to be brought before it within 30 days for a hearing. The court may order that the person may be required to serve a sentence of not more than 90 days without diminution of the sentence, which means reduction. But this is for a technical violation. So people is routinely called on the street a 90-day turnaround. So if you commit a technical violation, you can get up to 90 days. The defendant shall be given credit for time served prior to the revocation hearing for the time served in actual custody while being held for a technical violation. So that just means if a person is arrested for violating, they get credit. That time gets applied to their original sentence if they're revoked, or if they're only given revoked for a technical violation, they're going to get credit for the time they're sitting in jail. Subsection E deals with these things are not considered technical violations. If you're convicted of a felony, if you're convicted of a violation of Title 40, which deals with the drug laws, except for misdemeanor marijuana. So if you possess misdemeanor possession of marijuana, that's going to be considered a technical violation. However, anything above the misdemeanor amount of marijuana will not be considered a technical violation, and you can be revoked in order to serve the entirety of your sentence. Any intentional misdemeanor directly affecting a person, so if you punch, kick, slap, spit on a person, those are not going to be considered technical violations. If you get a domestic abuse battery charge, even if it's a misdemeanor, that's not going to be considered a technical violation. By law, it's not going to be considered a technical violation. Oh, actually, it covers it here. Any criminal act that is in violation of a protective order against a family member. If you possess a firearm while on probation, that will not be considered a technical violation, and you can be ordered to serve the entirety of your sentence. Failing to appear in court, the judge can revoke your probation. Obviously, absconding from the jurisdiction, so if you flee or leave, go to another state, country, when they catch you, you can be ordered to serve the entirety of your sentence. If you fail to complete a drug court program, your probation can be revoked. And if you, number 6, this is a big one. I've seen way too many people go to jail for violating number 6. At the discretion of the court, failing to report to the probation officer for more than 120 consecutive days. Listen, if you're on probation and you do not have the money to pay your probation officer the monthly supervision fees, go see him or her anyway. I don't think I've ever seen a judge revoke somebody who was doing everything they were ordered to do, but they just did not have the financial means to make the payments. Don't let that stop you from reporting. If that's the only thing stopping you from reporting, report every time and say, look, I'm doing everything I've been ordered to do. I just can't make the payment right now. And I think it would be very hard to find a judge who's going to revoke somebody who's reporting, has clean drug screens, has a job, hasn't committed any criminal activity, who's reporting to drug court and doing community service and everything they've been ordered to do, and just simply doesn't have the ability to pay. I don't want to see. I can imagine somebody being put in jail. In that instance, I look at it as if we're just putting a person in jail for being poor. I don't believe the judges in this state would do that. Everything else being in order, you don't have the money to pay, show up anyway. All right, this section deals with parole. She says if a person violates the parole officer if the chief probation or parole officer, upon recommendation by a parole officer, has reasonable cause to believe that a parolee has violated the conditions of parole, he shall notify the committee and shall cause the appropriate parole officer to submit the parolee's record to the committee. And then it just says what the possible penalties are: a reprimand, a warning. Additional conditions can be applied. The parolee can be arrested, and a hearing can be had to determine if they should be revoked to serve a part of or all of their sentence. I don't believe I've highlighted any other parts of this. Just know that the provisions of this act shall only apply to offenses committed on or after August 1st, 2024. Well, that's all I really had to share today. These are just new laws that are either taking effect today, the law that allows an 18-year-old to possess a firearm, that takes effect today. The laws dealing with probation and parole, good time, those take effect August 1st, 2024. I don't have anything else to offer today. If anybody has any questions, I'll take them. I'm going to play a couple of songs for you guys. Let me know what your thoughts are on the songs, if you like them or not. And then if you have thoughts on what you'd like to hear about in the future, it's with respect to Louisiana laws, criminal laws, laws dealing with respect to personal injury, or any other laws really. If I don't know about the law, I'll do my research, do my homework, look it up, and we can talk about it on here. Florida Ford, it's safe if you're popping fireworks. Somebody get injured or sued causing injury. Have a good day.
In the law, he's understood. Always calm and always fair. In the courtroom, never stare. Great elephant does declare. Injustice won't be spared. Great elephant, fighting for the right. Great elephant, great elephant, shining through so bright. In the courtroom's tall and bright. Great elephant stands with might. Justice served both day and night. Great elephant in the light. Wears a suit that's always neat. Every client he will greet. Victory never feels defeat. Great elephant can't be beat. Great elephant, fighting for the right. Great elephant, shining true so bright. When the gavel strikes the wood, great elephant does all he could. Wins the battles like he should. In the law he's understood. Always calm and always fair. In the courtroom with a stare. Great elephant does declare. Injustice won't be spared. Great elephant, fighting for the right. Great elephant, shining true so bright. In the courtroom's tall.
Great elephant in the court, stomping ground, defending the innocent, justice profound. In the jungle of the law, he stands tall. No case too big, no crime too small. Chains of guilt break with Trump and steel. From the boardroom deals to the courtroom field. Clients or objections, silky smooth. Clients breathe easy, knowing they'll groove. Shut like a defense, scales tip in his favor. Gavels begging, freedom is his flavor. Sweating, opponents guessing. Witnesses' tails twisted like a lesson. Feed his peanuts, but work juggernaut. In court he roars, untangling knots. From inches to street, he ain't discreet. Every verdict victory can't be beat. Great elephant in the wild of the law. Boundless wisdom, hefty and awe. Unchain the shackles, raise the tusks. Criminal defense, in him we trust. Silent steps in the courtroom corridor. Barks louder than a hard-nosed matador. Clients backed, defense tapped. Criminal defense, in him we trust. Silent steps in the courtroom corridor. Barks louder than a hard-nosed matador. Clients backed, defense tapped. Prosecutors trapped, his skills jacked. Elephant open in the courtroom, great elephant defending the innocent. Mind sharper than a tenement. Criminal defense, stronger than cement. Out here breaking cases so your time may spent. Suits clean as a glass, arguments intense. Great elephant in the zone, watch you commence. Skipping past objections, mind so immense. Law books battered, but the flow never fake. Strapping legal, heavy on the blocks. Great elephant, got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock. Tell the judge to relax, swaying up the wall. Jury nodding heads,